Good morning, everyone. Happy Monday. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So the first thing I want to talk to y'all about is dependent children who are listed in their parents' green card applications and what happens when they are no longer dependent children. So dependent children are those children that are under 21 and unmarried. So I always like to say the second your child is 20 years old and they get married, they are no longer your dependent and can no longer be a part of your green card application. So dependent children, again, are those children that are under 21 and unmarried. So when parents are in the green card process and they list that they have children on their application, your children can ride on your application without generally needing a completely separate application of their own, as long, again, as they are dependents under 21 and unmarried. Years ago, when we started sort of seeing a lot of these backlogs, some of these children, because the application for green cards were taking so long, they turned 21 in the middle of the process. And so then they were no longer considered dependents and they were no longer able to get their green cards through their parents. As a result, USCIS decided to see what they could do to change that. So what they did was they came up with the Child Status Protection Act, Child Status Protection Act, or the CSPA for short. The CSPA is essentially a way to calculate the age of a child, again, someone under 21 and unmarried, and it is to calculate their age in a way that allots for the time that an application is pending not to count against them as they, day by day, get older and older and older and inch closer and closer and closer to 21. So it is really a way to calculate their age in the hopes to give them more time before they officially turn 21. So I'm not going to go through like how we count it and how it is done. What I will say about the CSPA is this. For years, this way of counting someone's age under the CSPA has worked. There's been, quite frankly, very little complaints about it. So it really wasn't on anyone's radar screen, I thought, until very recently, USCIS issued a policy announcement, not a change in the law, but a policy change on how they were going to calculate the age. So essentially what they were doing in this new calculation, they're essentially going backward, and they are now using sort of the original policy that we had. We've had some policy changes. Before this most recent policy change, it was the most favorable to the children. Now we're going all the way back essentially to the original way that they calculated the age. And again, I'm not going to bore you with how we calculate it. But they're essentially going backward. So now as of August 8th, we are calculating the age slightly differently. We are using a different starting point. So in doing so, it will make it harder for some children to remain and have their ages considered to be under 21. So essentially remain dependent under their parents' application. So if you are thinking about applying for a green card and you have children, the closer they get to 21 in their age, the harder it may be for them to get their green card if there is a backlog or the processing time takes a while. So if you have children and you're thinking about applying for a green card, always better to apply sooner rather than later, so that you're not bumping up against this Child Status Protection Act calculation. So if you have any questions about your specific case and sort of the nitty-gritty of the Child Status Protection Act, feel free to reach out. But I just didn't want to go through sort of the math so early in the morning, frankly. The next thing I want to talk about is the J-1 visa. So J-1s are for people that are coming over and engaging in some sort of training or educational program. And there are several different J-1 categories that fit all up under the J-1. So for some of these J-1 categories, on the front end. So before you sign all the paperwork, you are told that you will be subject to what's called a 2-year foreign residency requirement. That means that once your J-1 program is over, you agree to go home for 2 years and essentially share the knowledge that you have received in the United States with either your home country or the country where you were last living prior to applying for the J-1 and entering the US. So this 2-year foreign residency requirement is in some cases extremely strict, but there is a waiver. There are waivers that you can get to essentially waive your 2-year foreign residency requirement. What we have started to see, and so what I want to remind people of, is in some cases, your home country needs to issue what we call a no objection letter when you want to waive that 2-year foreign residency requirement. That no objection letter for your home country says essentially that your home country has zero objection to you not coming back home for the 2 years and you remaining in the US. I think a lot of people thought that if the home country issued the no objection letter, that the Department of State would automatically say, okay, great, your home country doesn't have an objection to it, and therefore we as Department of State don't have an issue with you staying in the US. So the Department of State has always been able to say, it's great that you got a no objection letter, but we're still not going to approve your waiver and you still have to go back home. As a practical matter, in my practice, I have not really ever seen Department of State say no when the home country has said we have no objection. That, however, doesn't mean the Department of State couldn't have said no. So what we are seeing now is Department of State saying no, even after a home country has issued a no objection letter. So it is important to note that, one, even though your home country may issue that no objection letter and they automatically forward it to the Department of State, it doesn't mean that it does not mean that the Department of State now automatically has to approve your waiver. Two, it's also important to know that if you don't fulfill your 2-year foreign residency requirement or get the waiver, it means that you cannot change your status to most non-immigrant statuses. Most notably, one of those is the H-1B. So oftentimes people will reach out and say, hey, I have this J-1, now I want to switch to an H-1B, and then I want to get a green card. Well, the other thing you cannot do if you don't either fulfill your 2-year foreign residency requirement or get that waiver is apply for adjustment of status, meaning your green card. So it is super important to understand what the 2-year foreign residency requirement is, what the waiver process looks like, and understand sort of the reality of the waiver process. And the reality is that the Department of State does not have to approve your waiver, even if your home country issues a no objection statement. So it's fairly new from what I'm seeing that Department of State has said that they're not going to issue the waiver if the home country issues their no objection letter. So I'll keep you updated on that as we get more information. But that is something that you should keep in mind if you are, one, currently on a J-1 and you're subject to 2-year foreign residency requirement, or two, you are looking to begin your journey to the US in J-1 status. So just keep that in mind. So if you have any questions about your specific situation on J-1s and 2-year foreign residency requirements, feel free to reach out to us. We're happy to help you with that. The next thing I want to talk about is really family-based applications, which I don't talk about too often here on our Monday mornings, but I'm going to talk about them today. So USCIS has recently said that if a family-based application does not have all the documents and all the information that is required in an application, they can deny the application without issuing a request for further evidence or a notice of intent to deny. So usually what we would see is an application being filed. If the officer had additional questions, they would issue a request for further evidence. We would respond to that. If they had even more questions based on the response to the request for further evidence, they would maybe then issue a notice of intent to deny, saying, hey, you got one more shot at this, otherwise we're going to deny your application. we respond to that, and then we get a final decision. So now CIS is saying, we're not doing all that with y'all. So if you don't give us the information, like the basic information in the application that we need, we're going to just move straight for denial. So that sort of doesn't really please anyone outside of the agency, right? It makes it harder for people especially if they are doing their applications by themselves and they're not using attorneys. Not getting an RFE on its face and going straight to denial is, prior to this current administration, not the worst thing in the world. Not the best thing, but not the worst thing. What makes this new policy harder on family-based applications is family-based applications that are denied are now being sent over to the immigration court. And if the immigration court so chooses, those individuals are now being placed into deportation proceedings if they are out of status. So if they are denied and they do not have any underlying status, then they are being placed into deportation proceedings, and they are issued what's called a notice to appear document, which starts the deportation process. So I wanted to bring this up because I think this is a significant change in the whole sort of family-based process. But I also wanted to bring it up for my employers. So for my employers out there, I know sometimes the employers we will file a green card application and they will let lapse an H status, an H-1B status, or an L-1A or L-1B status. I always recommend that we maintain the H and the L just in case something happens to the green card application. I now am saying that even more. So for my employers out there, if you are working with an individual in your organization and you're sponsoring their green card, it is highly recommended that you continue to also sponsor their non-immigrant status in H and L and O that allows them work authorization and status just in case something happens to the adjustment application. So for my family-based folks who are applying for green cards based on family members, if you have an underlying status, to the best of your ability, maintain that status. And it is really crucial that you make sure that your application has all the proper documentation in it. Because for the family-based folks, getting a denial now could mean that you would then have your file transferred to the immigration court. So I wanted to bring that up for both my family-based and my employment-based folks out there. And the last thing I want to talk about this morning is the September Visa Bulletin. So we know that the Visa Bulletin is the chart that is released by the Department of State every month, and it tells us where you are in line for your green card and where they are processing those green card applications. So by what date, when you filed your initial application for your green card, that keys to the date in the chart. And then we look at the date in the chart and we say, okay, they're currently processing for your particular category all applications that were received before, let's say August 16th, 2025. So we haven't seen any movement between the August and the September Visa Bulletin. The Department of State, when they released the August Bulletin, dropped a note in there saying that they suspect that categories will become unavailable until the end of the fiscal year. Well, the end of the fiscal year is the end of September. The new fiscal year begins October 1. So what we are not seeing in the September bulletin that was released was visa categories listed as unavailable. So that's a good thing. It means that they still have visa numbers available. It means that they are still processing and approving green card applications. So typically when they have gone unavailable, sometimes midway through September, that is kind of what they're predicting. But again, we won't know till they crunch those numbers, as they continue to approve applications. Sometimes they will issue they'll issue a notice that says, these particular categories are now unavailable. So we'll see. I'll keep you updated on that. But as of right now, the categories that we thought might be unavailable are not. They are still available, as showing by the September Visa Bulletin that was released last week. So, and if it does go on, if some categories do go unavailable, it's only until October 1st, and then we'll have a new fiscal year. And this is not new. This happens, quite often towards the end of a fiscal year. It just seems a little wonky because it's always sort of in the middle of the year, in the middle of the calendar year. And so we don't sort of think about the government's fiscal year. But that is all I have this Monday morning. So if you have any questions about your immigration case, or if you're a J-1 holder and that 2-year foreign residency requirement, the visa bulletin, will give my office a call, and we're happy to set up a consultation for you. But have a great Monday and a wonderful rest of your day.